Slide adjustment.
This is the showdown moment, the kind of cross-examination where reputations hang by a thread. Cardi B versus a former security guard, and everything depends on whether this witness holds her story together under fire. So watch every hesitation, every, "I don't remember." In court, hesitation speaks louder than denial.
Miss Ellis? Your lawyer showed you photos of the building that you were working on at as a security guard in February 2018. Do you know the name of the building?
I don't know the name.
Was it Beverly Hills Medical Center?
It could have been, yes.
Yeah, it was a medical facility, right?
Yes.
And the incident that you claim happened that day happened at approximately 1:30 p.m.?
Approximately, yes.
And you knew at the time, when you saw Cardi B, that she was going to a medical appointment, correct?
I didn't know where she was going, but she was at the building.
And you understood that she was going to a medical appointment, right?
She was going to an appointment, yes.
And it was a medical building, right?
Yes.
Your deposition was taken and you said that you testified under oath in your deposition. Let me ask, do you remember your deposition was taken in this action?
Yes.
You remember taking an oath at the deposition to tell the truth?
Yes.
And that under the same penalty?
Backhand index pointing right, that's a tactical jab right there. When a lawyer reminds a witness they're still under oath, it's not just procedure, it's intimidation dressed as formality. It locks them into accountability. One wrong answer and boom, perjury charges on the table. The jury doesn't miss that tone either.
For perjury that apply in this courtroom, for example, correct?
Yes.
And you testified that you understood when you saw Cardi B that she was going to a medical appointment, right?
Yes.
Now, after this incident, you talked to your supervisor at Allied, right?
Yes.
And she told you to submit a incident report, correct?
Yes.
And you emailed an incident report to your supervisor 2 days later, right?
I don't know about 2 days, but I sent it to her, yes.
Yes. And it was by email.
I'm not sure how she received it.
Your Honor, if we may, I'd like to show the witness the incident report that she did not previously discover.
To refresh your recollection.
I would object to that based on authenticity. It's not her document.
Backhand index pointing right, the authenticity objection, a defense attorney's best friend. It's not about the paper itself, it's about planting doubt. If the jury thinks this report might be fake, the whole testimony starts to wobble. This isn't just evidence, it's psychological warfare.
This is a document that we got from Allied pursuant to a trial subpoena. And it's not in the book. So let me provide a copy. Should I hand it to the clerk?
You can push.
I'm sorry? Oh, thank you, Ron. Let's make sure. There you go. Does that refresh your memory that you sent an email to your supervisor on February 26, 2018?
Okay.
Do you recall that now?
I don't, but I'm looking at what you gave me.
And that's your email address, right?
Yes.
And it's addressed to your supervisor, Jason?
Yes.
And it's dated February 24, 2018? Oh, I apologize, it's dated February 26, 2018, and the subject is 224-18 incident report. Do you see that?
Okay. I see it, yes.
Yes. Now, before we talk more about that incident report, do you remember receiving in this case discovery requests that you had to verify under oath, where people asked you questions and got documents?
I'm not sure.
Let's see if we can refresh your recollection. With? Client's response.
Which one is it?
If I may, Your Honor, to explain to counsel that it's plaintiff's response and objection to defendant Cardi B's demand for production of documents, except 2. And may I approach?
Sure.
Thank you. Look to the last 2 pages. Is that a verification by you, signed by you, under oath, that the statements in the response are true and correct?
I'm sorry, were you asking me?
Is that your signature on the last page here?
Yes.
And you verified that, you signed stating that under penalty of perjury, the statements in the document are true, correct?
Yes.
Okay.
I'm not sure.
Well, please look at it. If you could please look at pages 5 and 6. The plaintiff has no emails related to this lawsuit.
Are you asking me about this email on the paper?
I'm asking you about the response. You made a discovery in this case stating that under oath you have no emails that relate to this incident. Is that
Well, that's
correct?
correct. I don't have access.
Backhand index pointing right. Wait a second. No access to the email that could prove her side of the story. That's huge. In civil court, missing evidence like this can tank your credibility. Viewers, be honest, if this was your case, would you buy that excuse or think something's being hidden? Drop your thoughts below.
This email anymore.
Okay. So you're, well, okay. Let's go back. Actually, we have one other response, another sworn response. Your Honor, I would like to show the witness plaintiff's responses to defendant Cardi B's special interrogatories, which, rather than asking for documents, ask for information. May I approach?
All right. Where's the date of the document?
It was served on January 3rd, 2024, and the verification is dated January 30, 2024. Yeah? Well. And that's your signature at the last page, verified under oath that the statements in the document are true and correct?
It's my signature, yes.
Okay, and you understood that you were verifying under oath that the statements in that document were correct?
Yes.
Okay. And in that document as well, you said you had no emails related to this incident, this lawsuit, right?
I'm not sure if I said that in this document, but
Could you please look at pages 4 to 5? In fact, you say it 5 times. And if memory serves, it's in bold.
okay.
And you never produced the email that you sent to your supervisor on February 26th in 2018 in this lawsuit, did you?
I don't have access to that email, sir.
My question to you is, did you ever produce that email?
I'm not sure I know what you're asking.
Did you ask, you had discovery obligations, Miss, did you ask Allied for a copy of the email that you are now testifying you couldn't access?
I wasn't in communication with Allied.
Okay, so let's talk about what you said on the email to your supervisor 2 days after the incident. If you look at page 1, it states that you were the
Backhand index pointing right. Here comes the plot twist, the paper trail. When witnesses forget, documents remember. And if this written report doesn't match her memory, the defense will pounce. This is the chessboard moment, one wrong line, and the queen falls.
guard on duty at 8920 Wilshire Boulevard. You were on patrol, and I had, quote unquote, I had two cell phones, the work phone and also my personal phone. I had my cell phone to my ear. Do you see that language?
Okay,
Do you see the language?
I see it, yes.
And you wrote that 2 days after the incident?
I don't remember writing this, but if this is what you have, then
Your Honor, I would ask that you read the whole sentence for completeness.
Well, I don't have it in front of me, so I don't know that, but to the extent.
Well, that's the portion I intend to read. I mean, he's welcome to read whatever he wants to read.
Well, he's just reading half a sentence. It would be unfair for me.
Why don't you provide a quote?
Yes, Your Honor. Well, let me actually include the declaration that came with it. Of ally.
Sorry.
Too much stuff. So we're talking about the first paragraph.
It does appear to be a narrative, so if you want to read everything in context, so.
Should I read it, or are you asking her to read it?
No, go ahead.
Okay. And just that sentence, Your Honor?
Just read it, whatever it is, make sure it's just in context.
Okay, thank you. Again, the context is that you state in this that you are a daytime guard on duty at 8920 Wilshire Boulevard. Per usual, I was conducting a routine patrol of the building premises, and as part of that patrol, I checked the rooftop, all tenants' levels, and parking garages. At approximately 13:30 hours, and just to clarify, that is 1:30, correct?
yes.
I was finishing a patrol on the 5th floor of the building. In my hand, I had two cell phones, the AUS work phone, and I also had my personal cell phone. I held my cell phone to my ear, checking my voicemail because my mother is recovering from cancer and is in chemotherapy, so sometimes I don't get the quick calls and have to check the voicemails. You remember that?
I'm reading it with you, yes.
And are you telling me you have no recollection of this 2-page email detailing the event that you sued over?
I remember writing an incident report and sending it over.
Well, do you recall also that you produced in this case your T-Mobile cell phone records, correct?
Yes.
And if I could, I believe that's something we can display because it is an exhibit.
Can you share, Your Honor, may I ask if they can share the exhibit number, please?
So why don't we, just to move things along, why don't we take our afternoon break now? Ladies and gentlemen, we're going to take an afternoon break. Since we have a couple things to discuss and I need to give the court reporter some time off, why don't we resume back at 3:15? In the meantime, please do not discuss the case with anyone, including other jurors. Don't call any opinions or do any research about the case. We will see you at 3:15. All right, welcome back, everyone. We're back in the record in the Ellis matter. Counsel and the parties are present, as are the members of our jury. Ms. Ellis, you're on the stand, and you're reminded you're still under oath?
Yes, sir.
All right, you want to resume your cross-exam?
This one. Let's back up just a little. 1 second. So, on that day in February 2018, when you were on duty as a security guard, you were wearing black boots, right?
Yes.
And you testified earlier when your counsel was asking you questions that you had a earpiece and you were checking voicemail. Well, I'm sorry, I mistaken. That you had an earpiece in your head when you saw Cardi B, right?
Yes.
And you were, but then in the incident report, we saw that you wrote that you had your phone to your ear, correct?
Okay.
Is that correct?
That's what it says on the paper, yes.
Yes. And if you look at that incident report at the very says from Amani Ellis, Amani Ellis at gmail.com. That's your personal email account, right?
Yes.
And is doing incident reports a normal practice in the security guard business?
When something happens, yes.
In fact, you do daily activity reports as a security guard?
Yes.
So the reports are very important, right?
Yes.
And in the incident report, when you were reporting back to your supervisor, you said that you were checking your voicemail.
Backhand index pointing right, and there it is, the detail that could decide it all. Nose or cheek? Small to us, massive in court. Consistency is king, and every contradiction plants a seed of doubt. The real question is, will the jury see a confused witness, or a story that's slowly unraveling under pressure?
Reporting on the incident that you have sued over,
Okay.
is that correct?
Yes.
Okay. If we could turn in the blue book to file exhibit 200. You see it?
Yes.
And that's a letter from your lawyer to me.
Okay.
Is that correct, ma'am?
Yes.
And if you go to the page that has a lot of blacked out entries, is it correct that that is a portion of your T-Mobile invoice, including for February 24, 2018?
Yes.
And you see that at 1:30, you received a call, and that lasted, what, 22 minutes?
Objection, Your Honor. The document does not say 1:30.
Oh, maybe my glasses are, I need to get a new prescription. Do you see the entry? It's 1:10 p.m. for 22 minutes.
Yes.
Okay, that was a phone call that you received and talked on the phone for 22 minutes.
Yes.
Okay. And at 1:40, you made an 8-minute phone call.
Yes.
And whose phone number is that?
Which time are you referring to?
310-403-3656.
I'm sorry, can you say that again?
Yes, absolutely. I apologize. 310-403-3656.
I don't know who the number belongs to, but it's probably a family member of mine.
Is that Nicholas Jackson's phone number?
Probably yes.
When you saw Cardi B, you said something to the effect of, wow, that was Cardi B.
Something to the effect of that.
And at that point, as a security guard, you knew it would have been improper for you as a security guard to tell people that Cardi was a patient at a medical facility, correct?
I didn't tell anyone that I saw her.
Could you please answer the question now? I can repeat it if you like.
Okay.
Isn't it true that as a security guard who had been trained, as you said, and worked for 4 years, you knew it would have been improper for you to tell people that Cardi B was a patient at a medical facility?
Objection, asked and answered.
It would be improper, but I did not tell anyone I saw her.
Move to strike everything after improper.
So now I just want you to answer the question, okay? So
Oh.
if you can answer the question with a yes or no question, please answer yes or no.
Yes, Your Honor.
And you understood when you saw Cardi B that she thought that you were using your phone to tell people that she was at a medical facility, correct?
Yes.
And as I understand it, you deny that you used your cell phone to photograph or film Cardi B on that day. Is that correct?
That's not true. I didn't record her or film her.
The question was, is it correct that you denied using your personal cell phone to photograph or videotape Cardi B on February 24, 2018?
Yes.
Objection to bacon and videos.
Overruled.
And isn't it correct that you don't have that phone, right? You no longer have that phone. You disposed of it. You can't show us that phone and show that you don't have any photographs or videos of Cardi B. Isn't that correct?
Yes.
And rather than simply leaving, you stepped out of the elevator and told Cardi B to repeat what she said. Say it again. Isn't that what you did?
No.
Well, if you look at the incident report, quote, you see in the second paragraph, I stepped out of the elevator and asked her to repeat what she said to me, and so she did, angrily putting her finger in my face and yelling at me. Do you see that?
I stepped out of the elevator to clarify.
And you told her, say that again, right?
I don't remember saying say that again.
And your testimony was that you and Cardi B yelled at each other for 30 seconds.
She yelled at me. My voice was firm because I was upset.
Are you denying that you testified at your deposition and stated to Dr. McKenzie that you were yelling and cursing at Cardi B?
I'm not denying it. I just wanted to clarify.
And as you were yelling at Cardi B and people stepped out of her doctor's office, one of them stepped in between you to separate you two. Isn't that correct?
Yes, because she was in my face.
And the people came out of the woman's care doctor's office?
Employees came out from the 5th floor. I would assume they were from women's care.
And the woman who stepped in between you came out of that office?
I believe it was her, yes.
And you testified in your deposition that Cardi B spit at you after the other people came out of the doctor's office. Isn't that correct?
She did.
Move to strike as non-responsive. And if
Why don't you clarify the question?
you testified at your deposition under oath, you said at that point that Cardi B spit at you after the other people came to intervene in the argument. Isn't that correct?
Yes.
And yet, in the report, you state I advised Cardi B that she needed to get her finger out of my face because I had not did anything to her. She then responded by spit at me, that's how it's spelled, and as a result, I became angry and yelled out to her to leave me alone and go on about her business. A few moments later, I remember a few people coming out and trying to separate us. That's what you said in your email, correct? 2 days after.
Correct.
And you stated in your incident report that Cardi B's nails were 3 inches long that day.
They were.
Your Honor, if we could ask for an admonition for the witness to answer the questions I'm asking.
Yeah, so please just focus on the question and answer the question if asked.
Yes, Your Honor.
And the question is, you claimed in the incident report that Cardi's nails were 3 inches long that day. Isn't that true?
Yes.
And you testified at your deposition that Cardi pointed her fingernail at your face, right?
Yes.
And you state in your February 26, 2018 incident report, bear with me for a second, I have a copy of this one, and I couldn't. You state in your incident report that she scratched you on your nose, right?
Objection misstates the testimony of the witness.
Well, it's contrary to this. Sorry, Your Honor.
Overruled.
You testified in this trial, that Cardi B cut your cheek, yet you stated in your email to your supervisor on February 26, 2018, that Cardi B cut you on the nose. Isn't that true?
Objection misstates the testimony.
She put her finger in my face.
Okay, first of all, you have testified here today under oath that Cardi B, 7 years later, that Cardi B cut your cheek, your left cheek. Isn't that true?
Yes.
And you state in your report 2 days after the incident that she scratched your nose.